5 steps to probate a will and get letters testamentary in New York City. If a relative passed away with a last will and testament, you may need to probate the will. Here are the 5 steps. Step 1. Write down all the names and addresses of all people or organizations who are mentioned in the will. Additionally, make note of the decedent's next of kin, which is typically the decedent's spouse or children, but in more complex cases can be cousins or distant relatives. Step 2. Gather the original will and one copy of the will. Gather a certified copy of the death certificate. If the decedent was survived by only one person or by cousins, prepare and obtain an affidavit of heirship from a disinterested person. Step 3. Fill out the following forms, and there's a lot of them. First, the petition for probate and letters testamentary. Secondly, either a waiver of process consent to probate, known as a waiver, or a citation for everybody listed in paragraph 6 of the will. If the individual does not sign the waiver, then ask the courts to issue a citation that will be served upon the individual to appear in court. The third form is the notice of probate for everyone listed in paragraph 7 of the will. The fourth form is the affidavit of comparison. The final form is the affidavit of attesting witnesses. This form is only applicable when the will does not contain a self-proving affidavit. Step 4. Calculate the filing fee. When you submit the forms at surrogate's court, you will need to pay a filing fee. The fee is dependent on the value of the gross estate. You can see a quick example of the prices below. The final step, Step 5, is to go to surrogate's court and submit the forms. Note that you need to go to surrogate's court in the county where the decedent passed away or had property. When you arrive, go to the probate department, submit the forms, and pay the fee. If your situation has odd circumstances or nuances, or if you just have questions, feel free to contact us with the information provided. Thank you, and best of luck.